Jerry Brock was convicted of child SA in the first degree in 1995. He was sentenced to life without parole under the persistent offender statute. His victim was 11 years old at the time, but in 2012 she recanted her previous statements and declared the crime never occurred. She blamed Brock for her mother's drug use and just craved her mother's attention. The following year, in 2013, the courts found the victim to be credible and vacated Brock's conviction without prejudice, and the case was dismissed. Mr. Brock then filed a claim under Washington's Wrongly Convicted Persons Act requesting compensation, but the court denied that claim. Brock is now appealing the trial court's decision, arguing the trial court erred when determining he didn't demonstrate actual innocence with convincing evidence, and that the court imposed an impossible legal burden contrary to the purpose of the Wrongly Convicted Persons Act. Let's take a look.
This is a case that involves three tragedies. The first relates to the childhood experience of Regina Rush, whose mother, Charlene, was in and out of jail and abandoned her due to her drug addiction. The second tragedy is a result of the first, and it pertains to Jerry Brock, who was wrongfully convicted for crimes that he did not commit and that in fact did not occur. The story in 2012, when Regina had grown up and extricated herself from the difficult circumstances, she, in an act of restoration towards her mother, told the truth about how harmed she was by that abandoned childhood. That, as the court knows, led to Mr. Brock being released from prison, and now we're here because of a third unfortunate tragedy below. Despite the true, credible, and reliable testimony that Brock was innocent, the court below denied Mr. Brock's claim under the Wrongly Convicted Persons Act. And for three separate reasons, we ask the court to reverse. The first is, as a legal matter, the court erred by failing to recognize the impact of the recantation evidence on the prior allegations from 1995.
So why don't we stop there and you discuss that more fully?
Yes, Judge. That was my plan.
All right.
So Judge Price, after a reference hearing in 2014, found Regina's testimony to be truthful and credible, and not motivated by anything other than her desire to tell the truth. By the time this case went to trial at the WCPA trial in 2022, there was more evidence supportive of the veracity and truthfulness of the recantation evidence.
Tell us about that more evidence.
Yes, Judge. So there are, I think, 5 different things. So the first is the testimony of investigator Julia Armijo, who located and found Miss Rush, Regina Rush, and testified about her testimony and interviews that occurred before the reference hearing testimony that occurred in front of the defense attorneys and occurred with the prosecutor's office and in repeated moments. There was testimony from Pat O'Connor, another defense attorney who was present during these meetings, as well as Larry Jefferson, another attorney who was also present, who described the testimony and the way in which it came about. Fourth, there is Anna Tolan, who presented a declaration in 2022 about Miss Rush, and she said in that declaration, Miss Rush stands by her testimony in 2014, and she also described some of the circumstances and trauma that Miss Rush has experienced in her life as a child and as an adult. And then additionally, not present at the original trial, but present at this trial, was Brock's testimony that he was innocent. So there's 5 different things that existed between the 2014 hearing and the trial in this case that corroborated Mr. Brock's innocence. There wasn't the type of thing that might exist in another case.
I mean, I've got 2 problems, both of which might need to be talked about. One is the standard of review. I mean, your brief of appellant seemed to, I think, labor at some disadvantage based on the view that this is de novo review, where we would take all those things you just described and ask ourselves, how credible do we find them to be? I'm not convinced that it's de novo review because you had a trial in front of a fact finder and under a statute that would have allowed it to go to a jury. And maybe you could address that before I tell you my other concern.
Yes, Judge. So I think here there's no dispute that when there's a question about how the law is applied based upon the findings of fact, that is a question that's reviewed de novo. So I think in this particular case as well, there is a statutory mandate in RCW 4.100.060.3 that requires a fact finder to weigh evidence and consider time. That does limit the discretion that may otherwise apply. And so we are making legal arguments that I think would be subject to de novo review, and that wouldn't only be factual assertions associated with the reviewed for substantial evidence.
Aren't they colored, however, by the fact that the trier of fact looked at those pieces of evidence you just described and concluded they weren't very persuasive? We don't review that.
I think that in this particular context, this is a different proceeding, and the statute here, which I just mentioned, 0603, does limit a trial court's discretion to weigh evidence. That's the way that the provision works. And even when the court...
So would the remedy for that be for us to countermand the way the evidence was weighed, or to send it back after having, on a de novo basis, determined the correct statutory standard?
The court could do both. So the court could say that based upon the legal error that occurred here in not assessing the impact of the recantation testimony on the original trial evidence, that was a legal error, and reverse. The court could also remand and say, here's some legal errors that we found, and the court should adjust its ruling in light of them.
So my second issue, at risk of monopolizing your time, is you seem to have characterized this case in terms of two polar extremes of certainty. Either we know he did do it, or we know he didn't do it. But isn't the reality that there can be uncertainty, and isn't the result of uncertainty usually cutting against the party having a burden of proof by clear and convincing evidence? Isn't the trial court saying, I just don't know for sure, which means the plaintiff loses?
I think that you're right, that there are levels of in-between that exist in the universe. However, Your Honor, in this particular case, and this court does review things, there have to be reasons. And one of the things the statute requires here is that those... May I finish my answer? Thank you, Judge. Is that in this particular case, there was no reason to find that Regina's testimony in 2014 wasn't truthful or credible. And in fact, the court found that it was credible. The consequence of that means something. And so it's logically inconsistent to say, well, there's a separate competing event that exists out there in the world, because these aren't competing events with two different people. This is one person saying that I lied as a child, and that means something about the prior allegation. They're not sort of hermetically sealed in some different way. And it was a legal error, I think, to fail to appreciate the consequence of what a recantation means by definition on a prior allegation, particularly where, as here, the evidence that we might have presented at trial, whether it was from Regina, who was deemed unavailable, or Charlene, who had passed away, we weren't able to present.
Okay, you've answered my question. Thank you very much.
When you come back, I want you to talk a little bit about how we know that the court didn't weigh the credibility, which is different than truthful. Credibility and truthful are not the same thing. So why do we know that the court didn't weigh appropriately the credibility of the recantation against the credibility and all the other evidence at the prior trial?
Sure. I can just reserve 2 minutes and answer the question now, if that would be easier for the court, since it's on your mind. Sure. So I'll take the other minute. So here's how we know, is because the trial court didn't mention anything about it. So for example, it was stipulated that Charlene Rush would have had testimony to provide in this proceeding. That wasn't there. And I agree, if there is some light as it relates to between truthfulness and credibility, the way we know that the court didn't consider it was because of its analysis. These are not competing events. This is one person who came and made a comment about their prior testimony. And so what we know as well is there's no mention of Charlene Rush. There's no mention of the impact of the subsequent events subsequent to 2014, like, for example, Anna Tolan's declaration in 2022. And last, the way in which the court treated the idea that there was sort of some more evidence supportive of the prior allegations reflects an absence of consideration due to the passage of time, given the fact that evidence withered away while Mr. Brock was in prison, and the state just presented testimony from people who testified at trial who were themselves unavailable. And so it is an unfair standard held against Mr. Brock in that regard.
All right, thank you very much. We'll hear from your opponent, and if we could put 11 minutes on the clock, I think that would be appropriate.
Good morning, Your Honors. Marco Hananel for the State of Washington. May it please the Court. To receive a financial remedy under the Wrongly Convicted Persons Act, Mr. Brock had the burden to prove that it was highly probable that he did not molest R.R. He argues that R.R.'s recantation should have been enough to carry this burden, but whether it was enough under the circumstances of this case was a question of fact for the trial court to determine. This court should affirm for two reasons. First, under a mixed standard of review, this court will review the determinations of fact only for substantial evidence, and the conclusions of law will be reviewed de novo. Because it's clear on this record that the trial court properly understood and applied Mr. Brock's burden in this case, only questions of fact remain. Second, those questions of fact, how to resolve conflicts in the evidence and the weight to apportion each piece of evidence, is supported by substantial evidence in this record.
So could you speak to the idea that the trial court failed to weigh the recantation, current recantation, and that credibility on the credibility and the verdict from before?
Well, Your Honor, the court made a determination that it was credible and internally consistent, just as it found that R.R.'s original inculpatory statements at trial were credible and internally consistent. And in that context, they're like any other form of evidence. They produced a conflict in evidence, just as Mr. Brock's statements during his police interview created a conflict with his subsequent statements that his subsequent denial.
I'm going to interrupt you for just a second. I apologize because I asked you a question and now I'm not letting you answer it. But there seems to be an assertion that it is different when the conflict is created is for the same person. Like this isn't, we have one person saying one thing and we have another person saying something else. We have a child witness saying something that was credible then, and then we have that same person as an adult who is credible saying, I lied as a child.
It isn't any different for two reasons, and I chose my example carefully. Mr. Brock's statements during the police interview, as presented through Detective Hovda, are Mr. Brock's statements, and they're compared against Mr. Brock's subsequent denials, and it produces a conflict. But if this case had been recharged as a criminal case and gone to trial again, once again, the jury would have heard both the recantation and the original inculpatory testimony, and it would have been posed with the question of how to resolve those conflicting things and determine whether there was any reasonable doubt as to Mr. Brock's guilt.
Mr. Brock's statements weren't as diametrically opposed to one another as the recantation. At the original trial, he said some things about what he did or may have done, but he said he didn't molest the child. And at the recantation hearing, he said, I don't remember what I said with regard to the other stuff, but I know I didn't molest this child. So that's not the same as I was molested by this person, I lied about being molested by this person.
It's nonetheless a conflict in the evidence, Your Honor, and it was one that was for the trial court to resolve. And I would note that the other case that, the case that Mr. Brock cites for this proposition, Ashby, also takes a look at the underlying recantation, and the underlying testimony, and compares it to the recantation and says that, recantations are not all equal, and they have to be carefully scrutinized because they're inherently suspect,
Well,
particularly.
in Ashby, though, there were several different versions of the underlying events. I mean, this case is a little more stark in a sense. I mean, we have two judges saying the recantation, it never happened, is credible. And, the last time I checked, both X and not X cannot be true.
That's correct, Your Honor. But what the trial court in this case was saying is that both of them are potentially believable, and then it looked to the other evidence in this case to determine that it tended to support the underlying inculpatory
Could the
statement.
trial court have possibly articulated that with a little bit sharper pencil than it did? I mean, the trial court describes both statements as credible. The trial court never quite says what you just said, which is both are believable versions of events, and I'm not sure which one is so. I mean, that's not quite explicit, is it?
Your Honor, I'm not one to quibble with the difficult position the trial court was in under this case, but I think it's implicit from other parts of the order. On CP 689, the court finally says the totality of the evidence falls short of persuading this court that it is highly probable that Brock did not sexually touch RR on the date in question. And it understood that that recantations, or rather that credibility, is not binary. It's not, as this court previously mentioned, it isn't the same thing as being true. And the court expressly acknowledged that they were conflicting events that the court needed to resolve. And here it found that once it looked at all the other evidence, Mr. Brock simply did not carry his burden to prove that it was highly probable that he did not molest RR.
Does this make it something of an insurmountable burden if your reason for actual innocence, the evidence is recantation evidence, as opposed to someone else confessing, or physical evidence, DNA evidence, or something like that?
It does not, Your Honor, and it's because not all recantations are created equally. There is a difference between, as is the case here, that a perpetrator, in a child sex abuse case, where the perpetrator is considered to be a member of the family and is subsequently sent to prison for life, versus a different recantation case where, for example, a co-conspirator or a witness who is already in prison for something is offered some inducement by the state to recant. Now, that isn't to say that one of those inherently doesn't work and the other one inherently does work, but those are the sort of contexts and circumstances that the trial court, as the finder of fact, is entrusted to resolve. And it does not create a situation, as Mr. Brock argues, where no one whose WCPA claim is based on a recantation can possibly succeed.
Did the court not consider all of the other evidence that Mr. Brock put forth at the recantation or the second hearing?
Well, I'm not aware of any case, and Mr. Brock doesn't advance one, that says that a trial court has to mention every single piece of evidence that it considers in its order. And I would also point out that under
It does in summary judgment orders.
which this is not, Your Honor. But I would also point to the standard of review, which is that in making a sufficiency determination, an appellate court need only consider evidence that's favorable to the prevailing party. So in this case, the court would look to the evidence that supports the trial court's judgment, and it need not consider every single piece of evidence that Mr. Brock
Is that a question of first impression under this statute?
Your Honor, the statute is mostly questions of first impression. I am unaware of another jury, I'm sorry, I'm not sure. Yes, I think that, without going on too long, yes, I think it probably is.
I mean, it specifies a standard of review for a dismissal,
It does, Your Honor.
but post-trial, I think it's silent.
Yes, and in that circumstance, the prevailing law used in other contexts should apply. And the appropriate standard of review here for a finder of fact would be deferential to that.
Given that the statute says that the things like the difficulty of proof need to be considered, did the court need to make some findings with regard to that? And are the findings that were made sufficient?
Yes, Your Honor. Under 4100.060 subsection 3, I'd point out that on this record there really aren't any pieces of evidence where the difficulty relates to the passage of time. The only one Mr. Brock indicates is the one dealing with the unfortunate passing of RR's mother, Charlene Rush. And insofar as that she could possibly have testified that she believed RR, that she supported RR through the recantation process, that's either cumulative, other evidence in the record, or it's irrelevant.
She could have said more, though. She could have commented on the relationship she had with RR and that would go to RR's alleged motivation for the original report she made.
It's possible.
She might have remembered other facts from the night of the alleged incident.
It's possible. 060 subsection 3, however, does not require the court to speculate as to what possibly could have been testified. And Division 3 of this court previously interpreted 060 subsection 3 not with respect to weight, but with respect to the admissibility of evidence. And the plain text of that statute requires due consideration in the exercise of the court's discretion. And in Larson, the court found, with respect to the admissibility provision, that that was reviewable only for an abuse of that court's discretion. It had to be manifestly unreasonable.
I mean, it seems to me that the merit of your argument is further suggested by the fact a jury could be deciding the fact questions. And, I mean, short of instructing them, you know, it would have to be resolved through admissibility in that scenario.
That's correct, Your Honor, and I think it also speaks to any alleged inadequacy in the trial court's order, because in the case of a jury verdict, there will be no explanation for exactly what they settle on.
Well, except that it's very clear that we do look at findings of fact and conclusions of law differently from a general verdict.
That's correct, Your Honor. If there are no further questions, and for these reasons, the state respectfully requests that the trial court that this court affirm the trial court's judgment.
All right, thank you very much.
Thank you.
Oh 0603 requires the trier of fact to consider things like the unavailability of witnesses when it weighs the evidence. And I agree that a jury might present a different situation. That's not what we have here. But as was mentioned, Charlene's Rush's passing did impact Brock's ability to prove his case, but that wasn't the only thing. Also, there was Regina Rush.
What do we do about that, though? I mean, it can't be that the legislature meant for the court to imagine something she might have said.
Yes, I think that when it comes to the statement that the trial court made that the other evidence is more somewhat supportive, that's indicative that it's not considering the unavailability of other types of evidence. So the trial court here.
But help me with that, because we can't imagine evidence that doesn't exist.
That's right, Judge.
We have to decide cases based on the evidence it does, and that's why we have burdens of proof as a fallback when we just don't know.
Well, so there is circumstantial evidence here that Charlene Rush was supportive of Regina, but when it's about assessing what evidence does exist. So, for example, Mr. Brock doesn't remember every detail of his interrogation, and you're comparing that against a transcript of an unavailable witness. Be like, well, here's all of these very specific questions. There's a discrepancy there in how the trial court evaluated that evidence, and so it's that statement that there's this other evidence is more supportive. It's not accounting for the lack of evidence that exists due to the passage of time. And again, it's not only Charlene, it's not only Mr. Brock's memory, but it's also Regina herself, who was declared unavailable at this particular trial. And so if those aren't things that we were able to surmount. And so it does run into, and I agree with the state, that not all recantations are created equal. This one is true, unequivocal, complete. It wasn't partial or anything like that. And in a situation where you have something like that, if I may finish my one sentence, Your Honor, the only implication here is that the prior statement was not true, and so we had asked this court to reverse and to enter a verdict in our favor or to remand with instructions.
I do have one more question, which is, so here we have findings of fact, and I guess I'm still not quite getting what the trial court was to have done with the absence of that evidence. Is there some particular additional finding that would have helped?
So I think that what the trial court should have done with that evidence is not found an evidentiary gap that contributed to saying Mr. Brock didn't meet his burden. So for a good analogy, I was anticipating this question was, well, how is a court supposed to do that? If you go back to Judge Price's order where he talks about the passage of time, he says, well, actually, the passage of time helps me see this as credible. Ms. Rush was clear about the fundamentals. And so what this provision prohibits the trier of fact from doing is using the unavailability of evidence against a claimant in meeting their burden, which is a higher burden than a standard civil case.
Thank you very much.
Following these arguments, the court affirmed the trial court's decision denying Brock's claim for compensation. The court found the conviction was supported by substantial evidence and the court did not abuse its discretion. What do you think about this case? Should Brock be compensated after spending almost 2 decades behind bars? Let me know what you think in the comments below, and please hit subscribe for new arguments every week.